Hello, my name is John Potter with the Potter Law Firm. I'm an estate planning and elder law attorney in Charlotte, North Carolina. Now today we're going to talk about living trusts. And many people think that the will is the simplest type of estate planning available to them, and in many cases they're right. The last will and testament is the most basic type of estate plan you can use, though most people unfortunately don't even bother to create that basic document. For many estates, though, the will is not as good an option as a living trust. While trusts are often considered a more advanced type of planning, they can often help to simplify and bring order to estates. They can do that in several important ways. First, living trusts can help avoid probate. The probate process can be a necessary part of settling an estate, especially in a nation where fewer than half of all adults even bother to create a will. Most people, though, prefer to avoid having their estates tied up in a drawn-out probate process after they die. The problem is there can be limited options to avoid probate, especially if your estate includes real estate or isn't eligible for any type of shortened probate process. Now, probate's necessary for assets that are in your sole name with no beneficiary designations, or for assets owned with someone else but not with the right of survivorship. Now, this is very common with inherited real estate. To avoid probate, you need to set up another way to transfer your assets at death. Sometimes this can be done with joint tenancy and sometimes with beneficiary designations. Both have advantages and disadvantages. A living trust provides another option, since you transfer ownership of your assets during your lifetime to the trust when you create it and you fund it. Now, many of us have planning needs that a standard will can't adequately address, but a living trust can. Some examples include if you have disabled heirs whose government benefits might be disrupted if they receive direct gifts under a will. A special needs trust can ensure that they receive their inheritance in a structured way that keeps them from losing their eligibility for benefits. Second example is the care for any pets you might be leaving behind. A pet trust could be an effective way to make sure pets' needs are met. Also providing support for your favorite charities. Charitable trusts can give you certain tax benefits while you're alive and ensure that your favorite causes continue to receive your support when you're gone. Also, heirs who are unwise with money or who have large outstanding debts. Spendthrift trusts can prevent those heirs from wasting their inheritance or having it consumed by creditors. This is often a big concern for families. Now, asset protection is often little more than an afterthought in estate planning, but some trusts can provide important tools to protect assets from nursing home costs, creditors, and potential litigants. It's important to note that revocable trusts won't accomplish this goal, since you keep control of the assets. You can revoke the trust and reclaim the assets at any time you want. An irrevocable trust, on the other hand, can provide asset protection by placing assets in trust, giving control to someone you trust while still allowing you to say how the assets will be distributed to your beneficiaries. Because you give up control and you can't take the assets back, they aren't considered your assets for creditor purposes, and your potential creditors can't reach the assets. That makes an irrevocable trust an important tool to use in nursing home planning and some other asset protection planning. Now, unlike these irrevocable trusts, a revocable living trust allows you to keep control over assets while you're still alive. And you can pick a successor trustee to take over if you're disabled or when you pass away. Until then, you can name yourself as trustee and use the assets however you want. The bottom line is that trusts are often very useful in your estate planning. If you have questions, reach out to an attorney who's experienced in estate planning and specifically in working with trusts.